Hi, I'm Arthur Bergeron, and the presentation you're about to see is the one that I have recorded for playing through the cable station in Hudson in July. This one is about planning to take care of your kids and your grandkids. What does your estate plan need to deal with to make sure, especially if you've got a child that maybe might have a divorce problem or a creditor problem or a disability, or if you're trying to leave money to the grandchildren, or if one of your kids has died and you need to leave it to the grandchildren. There's a million questions. And then, well, how do you answer those questions? What's the best advice to deal with? So if you've got any, watch this presentation if you got any of those questions. With me is my good friend Janice Long, who's going to tell you in the meantime what is going on at the Hudson Senior Center in July. Janice.
Hi, Arthur. How you doing?
Great. So nice to see you.
Nice to see you as always. In July, our Friends organization is having their cookout. They haven't had one in over 2 years. So we're having a cookout at the Marlboro Fish and Game in July. So we're looking forward to that. We're putting in some new fitness programs. A floor mat Pilates class is going to start. And also something that was kind of interesting is the health department has put together a very simple survey to find out if cost of the shingles vaccine is a deterrent for people getting it, because the shingles vaccine is covered under your Medicare Part D, your drug plan, and it's a tier 3 medication on most plans. And so the cost it's subject to the deductible, which is up to $480. So people have been complaining that the cost of getting the shingles vaccine is $180 for one shot. So anyway, they're putting together a survey. We're putting that in our newsletter. And the goal is to maybe in the future offer a shingles vaccine clinic in Hudson.
What a great idea. What a terrific idea. Because it's a big deal. And, I have a relative that's going through this, that she didn't get a shot, and it's been terrible. She's been like hell for the last 2 years.
It's expensive. It's expensive.
But the shot's expensive, but getting shingles is really bad.
Oh, I mean, that's really bad.
Terrible. And, and that's who, it's people like us, us old people. Well, not people like you, people like us.
No,
right?
me too, me too, Arthur.
So Janice, thank you very much for that summary. Folks, if you've got any questions on anything on the seminar, please give me a call, 508-860-1470. Janice, if they've got any questions, what's going on at the Senior Center? What's the number?
978-568-9638.
Janice, have a great July. Folks, enjoy your July. If we don't talk to you, we'll see you in August. Thanks so much.
Bye-bye.
Hi, I'm Art Bergeron. And welcome to this seminar, which is part of the series that I've been doing now for several years. And this one is all about taking care of the kids and the grandkids and the issues that come up often when I talk to people when they're trying to think of all of that out. So we're really talking about now what would happen after you died. So as you know, I always talk about my friends Frank and Mary and their kids, Peter, Paul, and Mary Jr. And when they were younger, they were concerned about this, but not as concerned because they know that when one of them dies, everything is simply going to the other. But in this presentation, that's happened. In this presentation, Frank has died. And so Frank has died, or they become divorced, or for whatever reason, Mary is now single and is trying to figure out what would happen to her assets after she dies. So the first question, of course, that I talked to Mary about, if we were talking about that, would be, what are the assets? So in this case, Mary has a house. It's worth about $400,000. She has a cottage worth $400,000. She has an IRA worth about $300,000. Savings worth $2 million. They have total assets of $1.3 million. So for many people here in the Metro West area where I live, they have a place at the Cape or in Maine or in New Hampshire. So the issue of the cottage is really common. For folks that I see on the islands, the other place that I work is on Nantucket and on Martha's Vineyard. Their house is the cottage. They're living in it now, but they're assuming that when they die, the kids many of them will have an interest in keeping the cottage. So it's relevant really to all of these people. So the question, there are a number of questions that Frank and Mary, that Mary would face in this case. By the way, let's start off with, well, what if Mary has no will? She may be coming in saying, oh my God, I really need a will in order to deal with all these issues. So let's be clear, first of all, what happens if she doesn't have a will. If she does not have a will, then her assets will go through probate and the rules of intestacy will apply. Those rules say that if she dies and she has no husband, her assets will be divided equally among her kids. If one of the children has died, then that child's share will go to that child's children. Incidentally, in a little quirk of the law, if two of her children have died, then the assets that would have gone to those two children will be equally divided among the grandchildren from those two children. They don't simply go according to if you have one child who died with 3 kids and one child who died with 2 kids, everybody gets pooled together. There are now 5 grandchildren who died and things get divided equally. But the bottom line is that's an unusual case. Any grandchild who is under age 18, the assets will be given to that child's guardian, typically that child's surviving parent, until that child is 18, at which point the assets will all be divided up. If there are no children of Mary, then when she dies, all assets will go to her siblings or to her nieces and nephews. Note, nothing will go to Frank's siblings or Frank's nieces and nephews. By the way, one important thing here is to note is that whether or not Mary has a will, all of these assets will go through the probate process, and we'll talk a little bit more about probate later on. So now we're going to talk about dealing with problems. Say, for example, that you want to deal with the daughter-in-law that you really never liked. And maybe that's Peter's wife, and you've never really gotten along with them anyway. Maybe there's a potential divorce in the offing. You really don't know how stable the relationship is. But in any event, you know that if you die and leave Peter's share to Peter, and Peter dies the next day, chances are the assets are going to go to this surviving spouse. So if you're concerned about that, especially if you're concerned about that divorce case, then you really want to think this out. So when you're thinking about that, you need to understand that first of all, the issue of how these assets would be treated in a divorce is state-based. Every state has different divorce laws. So if you were concerned about this, you'd want to make sure you knew what the laws were in the state where Peter lived, so that if there were a divorce, those are the rules that would apply. In Massachusetts, the rule is that if there is a divorce, assets get divided equitably, not necessarily equally. They are equitable but not equal. It's an important distinction. So judges have a great discretion when they're looking at the total value of the marital assets to say, well, you know, maybe we really want to kind of benefit one party more than the other in the asset distribution because one of the parties has more assets that are coming from a family, that might be coming from a family. That's a real issue. So when you're thinking about how to deal with this issue, you want to be thinking about how accessible these assets might be to, in this case, Peter, if there was later a divorce. The reason why I mention that is the issue is not necessarily whether the assets simply go to Peter, right? Even if they're in trust for Peter's sake, there may still be an issue, because the question is, well, among other things, so who is the trustee in that case of Peter's share? Is it one of the siblings? Does that sibling have complete discretion to distribute assets to the beneficiary at any time? And are there any caps on the amount that can be distributed? Because to the extent that there's complete flexibility, a judge may say, well, yeah, the assets are in trust, but, you know, not really, because the sibling is simply going to distribute all the assets to Peter. So in that case, if you're concerned about this, you may want to put some kind of cap on the distributions that might go to Peter following your death. You might want to name a professional trustee instead of a sibling. Or you may want to name the grandchildren as the beneficiaries, because if the assets are being allocated, the fact that assets are going to go directly to the grandchildren is probably not going to affect that allocation. So there are a number of issues that you want to be thinking out. So that's one set of possibilities, the issue of the daughter-in-law or the son-in-law that you're really not crazy about. How about the question of a child who has a disability. Say that Paul has a disability of some kind. The question there is, how will a distribution to him affect his government, his government benefits? I mean, it would be a shame to think that you're leaving a whole money to Paul, and the result of it is that he's no longer eligible for money that he otherwise would be eligible for through a government program. So when you're thinking that out, you need to think that out asset by asset and program by program. So the question is, if Paul has a disability and is on a government program or might be on one, what are the rules of that government program? For example, I often have the situation where parents will tell me that, oh, my child is disabled, he's on SSDI. SSDI is the program, or Social Security Disability Income, is the program that is designed really to help people who because they no longer have the ability to work full-time, can't really wait until they retire before receiving some kind of benefit that allows them to continue to live life. So SSDI is based on this assumption that you had worked, that you earned a given number of, that you worked and contributed into the Social Security system for a given number of quarters, works just like regular Social Security. But that after that, for some reason, because you had an accident or for whatever other reason, you became totally and permanently disabled. That's the definition, totally and permanently disabled. If that's the case, then Social Security, through SSDI, will pay you a regular check until you become 65, at which point you'll switch to the regular Social Security program. The point, though, is that you get that check no matter what your other assets, and no matter what your other unearned income. So if Frank and Mary, or if Mary decides that she wants this share of the assets to go in trust for Peter's benefit, right? She doesn't have to impose any kind of limits on the amount that he can get. Similarly, she can simply give the assets to Peter because there is no asset limit, and to the extent that he's getting income from any of these assets, there's no problem with that. Mass Health, on the other hand, that is the medical insurance program that is really designed for poor people, does have an asset limit cap. So by leaving assets to your child who is on Mass Health or who may need Mass Health in the future, you may be making him ineligible for that program. In that situation, you probably want to leave those assets in trust for his benefit. Supplemental Security Income, or SSI, which is often confused with SSDI, is a program not designed for a disabled person necessarily, but designed for a person who is simply poor. And the point of the program is to supplement your income up to a particular minimum amount. And those minimum amounts are really small, typically less than $1,000 a year. And to the extent that you leave, and this is an asset-based program, so that to the extent that the recipient has more than really only a few $1,000s in assets, that person is ineligible. But it's also income-based. The point of the program is to supplement income up to that magic number, so that to the extent that there is a guaranteed income coming from someplace that will cause him to get to that number otherwise, he's going to be ineligible. So you really need, in that case, what is often called a supplemental needs trust. You need to give the trustee, typically the trustee in that case is the sibling, you need to give the trustee the discretion to distribute assets to the beneficiary. There are some limitations regarding the kinds of things that the money can be used for, like even housing or food. And then if you're trying to structure something for Paul's benefit in this case, or the benefit of your disabled child, you need to figure out where the remaining money will go after that child dies. Finally, there's the more general, oh, you know, I have a child and he or she doesn't have a disability, but they're kind of a mess. You know, they have creditor problems, they don't pay their taxes, or they don't have good skills managing money. So in that case, you may want to specify that those funds are going in trust for that child's benefit. It has been my experience that in that case, the other sibling is often not the best beneficiary or the best trustee, because typically in that family situation, there's been tension between the sibling who is kind of a mess and the sibling who is irritated that the other sibling is kind of a mess. And you probably don't want to deal or set up a situation where your death causes actually increased friction among those siblings. In that case, you really may want to consider naming somebody else as a trustee, naming a niece or nephew, naming a good friend. You can certainly name a professional trustee, but why pay the money? The person that you want to name a trustee based on how much you trust them. You don't need that person to have special legal or financial expertise. The trustee in that case could always hire the expertise. What you really need is the trust. Finally, in that situation, as in Paul's situation, you want to make sure that you've dealt with what would happen to any remaining assets after that child has died. So, in addition to issues involving the children, sometimes folks want to talk about dealing with the grandchildren. Sometimes they want to leave money directly to the grandchildren, perhaps to pay for college. Oftentimes, grandparents are contributing to so-called 529 plans. The point of these plans is that the money that you put into them, while you had to pay tax before you put the money into the fund, the interest or the income that is derived from that fund is not taxable to you unless you withdraw the funds, because you retain the right to withdraw the funds anytime during your lifetime. And then if the funds are ultimately used to pay for the grandchild's education, then those funds are not taxed to you at that time. Instead, they can simply go directly to the college or university or high school, actually, where that child is going. If you're thinking about doing this, you want to think, though, about the effect that those funds are going to have on that child's college application. We always refer to it as the so-called Fafsa Form that any parent will tell you that they've seen before and that they kind of dread filing. The point of the Fafsa Form is to allow colleges to evaluate how much student aid the child might be eligible for and how much the child can afford to pay for. In that evaluation, each college sets its own criteria, but it is not uncommon that 529 money or money that the child just has, that they inherited, even if it's in trust for that child, will get applied to how much that child can afford to pay for that child's education, dollar for dollar. On the other hand, if you simply leave those assets to the parent, right, of those children, to your children as opposed to your grandchildren, in that FAFSA application, the FAFSA will look at the assets of the parents, but will typically only attribute a percentage of those assets. And this percentage also varies by college, and it varies depending on which child this is, whether this is your first child going to college or second or third. They'll only attribute a percentage of those assets to the potential use for that child's education. So you may want to think that out before you try to figure out how that is going to work. Finally, there's the question when money is going to the grandchildren. We talked about this earlier. If one of your children were to predecease you and money were going to the grandchildren, of who manages that money and until what age. You can pick any age at which the grandchildren would ultimately be able to receive the money. In the meantime, though, typically you'd have a trustee for the benefit of those grandchildren. In that situation, we often recommend that one of your other children be the trustee for the benefit of those grandchildren. It has been our experience that otherwise you may run into the situation where your deceased child's spouse ends up remarrying, and suddenly there are funds available for some of her children and not for other children. There can just be problems. So typically in that situation, we recommend that one of the other siblings, or if you don't think that that's going to work, another family friend or another relative act as the trustee in that situation. So the question then, once you've figured out what the issues are regarding giving assets to your children or giving them to the grandchildren, is what the vehicle will be through which you can make that happen. There were really three basic ones. One, you can have a will, certainly, and the will, in the case of the examples that we just gave, may have trust provisions in them, dealing with either the children or the grandchildren. Or you can have your assets held in joint ownership with somebody, so that upon your death, the assets instantly go to someone, presumably one of your kids. Will often have that occur, that someone will say, well, I'm simply going to leave all the assets to one of my kids, and I trust them that they're going to deal with all this, right? Or you can, as an alternative to all that, create a revocable and amendable trust. We'll talk about that a little bit more later. So first, there's the quickest, the least expensive way to handle these issues as far as you're concerned, and that is you would simply have all of your accounts, for example, in joint names with one of your kids. Like we'll take in this case Peter, because you're trusting, and put your house in joint names with Peter, put everything in joint names, because you're trusting the fact that if you die, Peter's going to take care of all of this, and he's going to distribute the assets. There's no problem with structuring things that way, since contrary to popular myth, there is no gift tax. So if you simply leave everything to Peter, and then Peter turns around and gives the assets to his siblings, that's not going to impose a gift tax on Peter. The receipt of a gift, just like the receipt of an inheritance, is not income, and so it's not going to change the income tax situation for any of your kids. That all works fine, unless it doesn't, unless there's a problem, because first of all, you are now counting on the fact that Peter's going to do all of this. And he may, right, or he may not, because once the assets are his, he has no responsibility to distribute them to anybody. Also, going back to the case of the daughter-in-law that you don't like, if the assets are now his, that means if there's a divorce, those assets are in play. All of the assets are in play because he owned them. Even if he subsequently gave them away, a court could say, well, you could have kept those assets. So there can be problems with that situation. This plan works the best if you only have one child. The second possibility, of course, is the will, that you simply take all of the rules that you've now discussed and figured out, and you put them all in your will. Now, and that all works. That all works. And assets will be distributed according to the will, ultimately, after the assets have gone through the probate process. The issue with that, though, is any asset that you own simply in your own individual name has to go through the probate process before the asset can be distributed. So oftentimes I'll hear, well, I have a will and so I don't have to go through probate. No, that's false. As I talked about earlier, a will determines where your assets go. If you have no will, then the assets go according to the rules of intestacy that I talked about. If you have a will, then they go according to the terms of your will. Before any assets can be distributed, though, they have to go through probate, which means they're subject to the claims of creditors. And creditors in Massachusetts, this varies a lot by state, creditors in Massachusetts have 1 year from the date of death in order to file a claim against the probate estate, which is why probate always takes at least a year. This is not because your lawyer is being lazy. It is because we all have to wait to make sure that there are no creditor claims. Now, I know you're going to say, but I don't have any creditors. That's not the point. The reason why the law is there is to make sure that even if you forgot some creditors, or even if they show up as a result of your death, you got into a car accident, you died, somebody else got hurt, these assets are going to be available to creditors, right, during that 1 year period. Actually, from the creditor's perspective, that statute of limitations, that period during which a claim can be filed, actually is shorter than what they would otherwise have been allowed. If you had gotten into that car accident and died and hurt somebody, if you were still alive, that person you hurt would have 3 years in order to sue you. They would only have 1 year from the date of your death in order to sue the estate. The point is, though, from the perspective of your kids or your grandchildren, that year could be a long time. The other issue is, of course, that going through the probate process involves legal costs. Our experience has been typically between $3,000 and $10,000, depending on the complexity of the nature of the assets, the complexity of the situation, and to the extent that there are disagreements among the kids, that's the place where those disagreements can be fought out in court, in public. To the extent that you're concerned that somebody may contest any of the things that you have said, therefore, you really want to try to avoid the probate process. Third possibility is a revocable and amendable trust. What does that mean? Revocable means whatever you put into the trust, you can't take back out of it. Amendable means, as the name implies, that you can amend the trust at any time. It becomes irrevocable and unamendable when you die, because at that point you can't take anything out, and of course you can't amend it. So you could take all of the rules that we had just talked about and put them into the trust, name yourself as the trustee of the trust while you're alive so that you can retain complete control of all of these assets while you're alive, but then specify who the successor trustee will be following your death. Typically that will be one of the kids, although it can be anybody that you want. The point, though, is that the day after you die, that successor trustee can then step in and deal with all of the distribution of all of the assets. There are immediate distributions, much less likelihood of an argument that leads to a court case. Finally, there's the cottage. And we talked about the fact that, whether you live around Metro West and have a cottage on the Cape, whether you live on Nantucket or Martha's Vineyard, and therefore the kids really want to keep that house following your death, you may have a desire to keep those wonderful times that you have at that cottage going for the rest of your life. What you don't want is to cause your death to be the cause of friction among your children or grandchildren. So in that case, you kind of have two options regarding how to deal with the cottage. One is you could try to figure out now what the rules are going to be regarding how that cottage is going to be managed. It has been our experience that if you figure out the rules, you're the parents. So no matter what the kids think about how you set up the rules, they're going to abide by the fact, hey, this is what Mom and Dad wanted. We may not like it, but it's what Mom and Dad wanted. But in that case, you do need to figure out the rules. There are not an infinite number of rules that you have to figure out. It has been my experience. There were about 60 of them. When clients come to me with these kinds of issues, I send them this list and I say, figure out all of the answers to this list, and you've pretty much covered everything. But to give you some sense of what those are, say that you've got a cottage on the Cape or on one of the islands. The first question is, everybody gets to use the cottage, but when? Typically in chunks of a week. Well, what's a week? Does a week start Saturday? Does it start Sunday? When does it start? And then who cleans the cottage between the time that one is finished and the other one has started? Who figures out the budget? Who's going to pay the taxes and the insurance? And when are those bills due? Who collects all that money? What happens if somebody doesn't pay? And then how does it all, what happens if somebody wants to buy out because they live on the West Coast and they're never going to be coming to live here? What happens at the end, and how does the end get determined? There are a number of issues that you probably need to decide. Then there's the simple way, the nuclear option. You say in your will or in your trust, if the kids have figured out within 6 months of the date of my death otherwise how things are going to be divided out, fine. Otherwise, the property gets sold and the proceeds get distributed. We were going to talk a little bit about avoiding the estate tax. You can avoid the estate tax by simply giving away things before you die. There are some disadvantages to doing that. I try to cover that more thoroughly in my presentation on estate planning for seniors. The main thing is that the goal of all of this is to figure out how you can get a good night's sleep. When you die, you're not going to be worried about your assets. If you're worried now, though, about how things are going to get distributed, figure out a plan and make sure that that's the way things are going to be, and then get a good night's sleep. If you have any further questions on any of this, you can always reach me by phone. It's 508-860-1470, or email me, or you can see this presentation again on Frank and Mary's YouTube page, which is Elder Law Frank and Mary. Thanks so much, and I hope you enjoyed the presentation.